25 DCCR 0963. My computer's going slow, give it a minute. You're charged with a first-degree felony offense of aggravated assault by discharging a firearm from June 12th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 5 years in prison up to 99 years or life. Do you understand? Answer out loud, please. And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 15 years in the institutional division of the Texas Department of Corrections. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I also want to make sure you understand, Mr. Jones, that after today, unless there's some new evidence that the assistant district attorney or your attorney gets or finds out, that this offer will not be accepted after today. Do you understand? Okay. And so, Mr. Jones, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial probably a little quicker. Is that okay with you? All right, Mr. Parker, you're released. Mr. Jones will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. All right, sir, you're Stephen Boudwin?
Yes, ma'am.
And let me get this pulled up. Is it?
And so if I can,
Hold on just a second. Let me just get what I need to, and then I'll let y'all. Oh, this is, I know. Would you call the name Tiffany Guillory, please?
This is the one I talked to your honor
Yes.
about on Friday. She bonded them out.
she actually, I wasn't sure about this. When he called me yesterday and about a bond here. I was thinking it was but I had requested a bond, didn't realize what it was. I said, well, you probably don't need to be there because he's already pled out on the case and we were waiting on a PSI. And we were going to see what happened with parole. I think he's been released from parole. The parole hold's been lifted.
No response.
And then I get a call from her, and she started explaining. I said, well, he needs to be there for the bond hearing. I don't know all the ins and outs about the issue about the increase of the bond, but she informed me as well that she had signed the bond to bond him out, and she sent a letter to the court, I believe, which was
I have
forwarded
it.
to me. And I told him that he needed to go and contact the probation department to do a PSI. I mean, I just told him yesterday. I don't know if he's contacted him yet or not.
Yes, they scheduled me to come in today. So I'm coming in off the court.
Ms. Malfino?
Thank you, Judge, and thank you again for your time while you were on vacation this weekend, and I was dealing with this matter with Ms. Guillory, who came to my office in tears, also tried to come to the court. I confirmed with your coordinator about that, in tears, about how fearful she was of this gentleman. So I immediately turned around and filed a motion to increase his bond, which time your honor graciously added some conditions of a GPS, et cetera, et cetera. I spoke with parole on Friday before I talked to you, Judge, and they were going to lift the hold. So that's when you put those conditions in place. I since have learned that obviously Ms. Guillory has now had a change of heart. She actually posted the bond herself. I was going to ask the court to reject the probation offer that I had given him, but in light of her actions, obviously I filed it, as the court knows, and you and I have both experienced, when someone expresses that level of concern, it's not something that we take very lightly, and yet her actions have proven that that was not serious to her, even though we all took it seriously. And so I would leave whatever decision you make, Judge, to your discretion. I'm not really concerned about the bond at this point.
So here's the thing, Mr. Boudwin. I'm not going to increase the bond based on what we've learned. However, a condition of your bond is still, and what has been the whole time, that you have absolutely no contact and no communication at all with Tiffany Guillory. She cannot give you permission to violate that order. Do you understand? So I understand she went and bonded you out. She's written me a letter. At this point, I don't care about any of that. Period. Now, once you're on probation, maybe some of that will change, but as of right now, no communication, no contact. That's in person, that's through your phone, that's through sending messages. Again, she cannot say, it's okay, I won't tell. If something happens and she changes her mind again, which is likely it sounds like, and contacts Ms. Malfino and says, okay, I thought it was okay, but now it's not, he's coming around, you're going back to jail and you probably won't have a bond. That's how serious I am about this. Okay, so we'll reset it. You need to take care of your pre-sentence report. You need to talk to probation, go there today, get that set up, and then we'll see where we are when we come back for sentencing. And you have that GPS device on? Okay, make sure you keep it charged, make sure you pay for it, do everything you're supposed to, so that I know at all times where you are.
I assume the sentence is still the same as on the 18th?
Yes.
Okay,
Uh-huh.
okay.
All right, okay, you're free to charge with a first-degree felony offense of aggravated robbery from May 16th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand?
Please.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison. You have every right to reject that. I want to make sure you understand if you pled to a cap, it means you'd be leaving your punishment up to me. If I follow that agreement, I can't give you more than 25. I could give you 25. I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have an absolute right to have a jury come decide all of this. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. I also want to make sure, Mr. Nichols, is there any reason to believe that that offer would change?
No, Your Honor.
Mr. Bates, unless there is some new information that the lawyers don't know at this time, I will not accept this plea agreement after today. Do you understand?
Yes, ma'am.
All right, Mr. Bates, also, Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney who can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. Mr. Bates, we will appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. And is it Briones?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Briones, in cause number 25, DCCR 1106, you're charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
I'm guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then in cause number 25, DCCR 1108, you are also charged with the first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation in each case. There would be a $500 fine. And then we would get a pre-sentence report done, and if there were any other recommendations or conditions such as ISF, that would be up to the court, and I could impose those at sentencing. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. Briones is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. I'm not going to adjust the bond just based on the nature of his age and the possibility of ISF. All right, you can go back with the bailiff.
Thank you, Your Honor.
Good morning, sir. Are you Derek Green?
Yes, ma'am.
And Mr. Green, in cause number 25, DCCR 1119, you're charged with the third-degree felony offense of obstruction or retaliation from June 19th of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, June 7th of 1999, and then after that was final, you were convicted of possession of a controlled substance, a third-degree felony, January 5th of 2000. And then after those were final, you were convicted of possession of a controlled substance, a third-degree felony, January 28th of 2008. Well, what that means is if you're found guilty in this case, and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go forward on count one only for an 8-year term in prison and waive those prior counts that would make you habitual. You have every right to reject this offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject this offer and have your case set for trial?
Yes, ma'am.
I want to make sure you understand, Mr. Green, that after today, I will not accept this agreement. Once your case goes on the trial docket, it will either be tried to a jury or you can plead either open to the court or something different than that 8-year term. Do you understand?
Fine, ma'am.
All right, so we'll get your case set for trial. Mr. Green, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. And Mr. Green, we will appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. You, Jacoby Lawrence?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Lawrence, in cause number 25, DCCR 1134, the state is elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment of a public servant from June 12th of 2025. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Lawrence is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm.
Yes.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yes.
All right, good luck to you, sir. You go back with the bailiff.
You have a credit.
And Mr. Guillory, in cause number 2240982, on probation for unlawful possession of a firearm by a felon. That probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
Yeah, it was with a vehicle. That's what, at least what the administrative hearing says, but
I don't know that it was a vehicle.
I haven't seen anything about it evading.
I think
It was only the.
My recollection was that it was evading on foot. I'm happy to explore it and check.
that's okay, let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. And the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly was
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
Oh, ma'am, Judge, this is argument.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Guillory had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case with the ag assault, understandably, it will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for the complainant witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before we come to court. And so that's what we ask for, Judge. Just, if we can get a bond that is a little more reasonable than $200,000, a bond that high, a lot of bonds from the courts, it's hard. A lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or, been going to court on that, my understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's, obviously that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that.
Yeah.
So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause it's not chocolate.
Gotcha.
I'm sorry, Judge.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is. Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offensive burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on, that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know, and we'll get someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff. 1102, you're charged with a second-degree felony offense of sexual assault from March 7th of 2018. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1103, you're also charged with the second-degree felony offense of sexual assault from June 9th of 2019. Again, that carries the same punishment range if you are found guilty, between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1104,
He's actually charged in 04 and 05 with aggravated sexual assault.
I haven't said those yet.
I understand, I think we checked off.
I did it right on the tablet. I was letting you know.
So in cause 25 DCCR 1104, you're charged with a first-degree felony offense of aggravated sexual assault from March 23rd of 2020. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? And then finally, in cause number 25 DCCR 1105, you're also charged with aggravated sexual assault. And this is from September 26th of 2024. Again, what that means is if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? I have here on the tablet plea bargain rejections in each of those cases that show that you've signed on with Mr. Rojas, that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for you to plead guilty on it looks like the aggravated sexual assault cases for 15-year term in the institutional division, to run concurrently on each of those aggravated sexual assault cases, so 15 and 15 that would run at the same time, with dismissals in the 2 sexual assault cases. You have every right to reject that and have a jury decide what to do in all 4 of your cases. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have all of your cases set for trial?
Yes, ma'am.
All right, we'll get that done. I do want to make sure you understand, Mr. Gibson, that after today, I will not accept this plea agreement unless there is new evidence that's received by the district attorney or your attorney between now and when we go to trial. If you want to change your mind and enter a plea of guilty, it would be to something different than this, or it would just be open to the court. Do you understand?
Yes, ma'am.
All right, and so Mr. Gibson, Mr. Rojas has been appointed to represent you. He's one of the attorneys that handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you are released, and Mr. Gibson will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff.
Tensions are high inside this Texas courtroom today. Multiple defendants, facing everything from aggravated assault to robbery, step before the judge one by one, but this isn't just another day in court. Behind every case, there's a twist. Rejected plea deals, emotional outbursts, and shocking reversals that even the judge didn't see. Watch closely, because in just minutes you'll see how one bond decision flips completely, how a victim changes her story, and how a single ruling could decide a man's freedom for decades. This is raw, real courtroom drama, and it's about to get intense. What an incredible series of hearings we've just witnessed. Let's break down what really happened inside this Texas courtroom. Because beneath all that formal procedure, there were powerful human moments, smart legal maneuvers, and a few serious warnings from the bench that you probably caught if you were paying attention. First, Judge Simpson starts strong, reminding defendants exactly what's at stake. Minimum 5 years, maximum life. It's a reminder that in felony court, every word counts, and that rejecting a plea bargain isn't just about pride, it's a calculated risk. For some defendants, like Mr. Jones, turning down that 15-year offer means trusting a jury to see something the prosecutors might not. But when the judge says, after today, this offer will not be accepted, that's real. Once a plea window closes, it rarely reopens. Then comes one of the most emotional turns, the case involving Tiffany Guillory. You could hear the confusion in the room. She once feared the man she bailed out, cried to prosecutors about her safety, and then suddenly posted his bond herself. The prosecutor's reaction says it all, disbelief mixed with frustration. And the judge, firm but controlled. No contact means no contact. That's a direct warning to both parties that the court doesn't play games with protective orders. No matter how the emotions shift outside the courtroom, moments like these reveal why bond conditions exist, not as punishment but as protection. The GPS monitor, the strict rules, the clear boundaries, all designed to prevent a cycle of danger or manipulation from repeating. The judge's message to Mr. Budwin couldn't be clearer. One wrong move, one phone call, and he's back behind bars. As we move through the docket, we see how each case unfolds in its own rhythm. Some defendants stand firm and reject plea offers, choosing trial over cert. Others, like Mr. Bionis and Mr. Lawrence, enter guilty pleas and accept responsibility. One getting deferred probation, another sentenced to 7 years. It's a powerful contrast. The same courtroom, the same judge, but completely different outcomes. That's the balance of justice. Accountability mixed with opportunity for reform. And then toward the end, we see the deeper complexity of probation violations and new felony charges. When the defense argues for bond reduction, it's not just about freedom, it's about survival. A man who says he just wants to get back to work, provide for his family, and fight his case from the outside. But the judge has to weigh that against the safety of the community and the seriousness of the new charges. That tension, fairness versus protection, is at the heart of every bond hearing. Legally speaking, what we saw here is the perfect example of how Texas courts handle overlapping cases. Plea negotiations, bond reviews, and probation violations all intersecting in real time. The judge stays steady, professional, measured, and crystal clear on expectations. She reminds each defendant that once they choose trial or plea, there's no turning back. That level of finality is what keeps the system running efficiently. But it also places enormous pressure on defendants to make life-altering decisions in minutes. Now, as we wrap up, think about this. Which moment stood out to you most? Was it the emotional turnaround from Tiffany Guillory? Or the calm but firm authority of the judge reminding everyone that the courtroom isn't a place for second chances? Let us know what you think in the comments, because every viewer sees these moments differently.